Good morning, ladies and gentlemen. Thank you for the invitation. Thank you for the opportunity. Thanks to the sponsors, which is also a compulsory part of any speeches nowadays. I understand that you probably expect this morning a political speech. I'm not sure that I would do that now. I might come to this at the end of my very, very brief introductory remarks. But basically, I thought that this is a very good opportunity at this conference to take a more neutral and a more objective, if you want to put it that way, academic or scientific approach. Of course, it will be used for political purposes anyway, but I think in this situation, especially with respect to the topic of this conference, it is extremely important that a fair, reasonable, objective, and neutral approach prevails. Professor Jakob referred to my double capacity. That also makes my job a little bit more difficult, because I always have to choose what kind of gown to take. So I try to be rather professorial at the beginning, and maybe I try to draw some conclusions from what I elaborated at the beginning. Now, it's not a new subject, it's not a new topic. It has been with us for at least 40 or 45 years. So nothing new about that. But it's still a topic which has not yet been finally decided. There is no final arbiter. I think it's good, because this is one of the driving forces of the integration process. Up till now, there has been a fundamental balance, despite some lingering conflicts, or at least the risk of conflicts. But never this conflict really materialized, and I believe that is a good sign. It's a very good sign also for the future of the European integration process. Provided the basic criteria of balance are maintained. So this is a subject that is the relationship between EU law and the law of the member states. Basically and primarily what I'm talking about is just the constitutional law of member states, so not the law of member states in general, because in all those areas not belonging to the constitutional law of the member states, the situation is very simple and very clear, okay, with some classifications or qualifications, but all in all, the real topic here is the relationship between EU law and the constitutional law of member states. This is an extremely timely subject, I would accept, even if it's not a brand new one, recognized. It's also intellectually challenging and stimulating. It is politically relevant, we can't deny it. And at the same time, it's not easy. And as I referred to this before, it is closely related to, in fact, it is inseparable from the general tendencies of development of the European construction. Especially in the last couple of years, much has been said about this. Much has been, even more, has been written about that in academic literature. Many people say and propose that after the redrafting and widening of the provision relating to national identity, the relationship between EU law and member states' constitutional laws will have to be reconceptualized. A more balanced and a more nuanced approach has to be taken. So, once upon a time, there was the theory of the so-called absolute primacy of EU law, or the supremacy of EU law, and that was very much in line with the that time conception of the geometric structure of legal rules in general. We all learned it in the law school, which was the pyramid, along the lines of Hans Kelsen or many other people. On the top, you had the jus cogens of international law, and underneath, in a very strict geometric model or order, you had the domestic legal systems. But then, after a while, European law was kind of inserted in that pyramid, but still the pyramid remained based upon a strict vertical subordination, a kind of, as I said, the geometric structure, a kind of pyramid. Now, it's clear that now we have to take a more nuanced approach. Not only because, in fact, this absolute primacy or supremacy has never been fully recognized by everyone. And I'm not referring only to the case law of so-called domestic constitutional courts, but also to Article 23, Para 1 of the German Constitution, which was quite clear when it said that Germany's participation in the European community takes place in accordance with its core constitutional principles. So it's not just the Ewigkeitsklausel, it's not just Article 79, it's also 23, which says quite clearly that everything must be in line with the core constitutional principles of Germany. And then, of course, came the case law, first in Italy, then in Germany, France, many other countries. And what we have to say now, after Lisbon, that a new relationship is being now established here. And many people now underline that instead of the absolute primacy, a kind of relative primacy has to be adopted. And the basis for this approach is first what we just discussed very briefly, is that the competencies of the European Union are the conferred competencies. Whatever is not confirmed belongs to the member states. That is the source of le pouvoir constituant, belongs to the member states. But more importantly, of course, you have Article 4, paragraph 2, which says, on the one hand, that the European Union shall respect the equality of member states. It's very important. But the text goes on and says that it also respects the national identity of the member states, inherent in their fundamental political and constitutional structures. So, as I said, this reference to the national identity has now been expanded by this reference to the fundamental political and constitutional structures. And that means, and that's perhaps also a semantic issue, here we are not speaking about nation as a cultural concept. We are not speaking about history, about language, or cultural identity. We may speak about that as well. But we do speak about fundamental political and constitutional structures, as it is clearly said in the language of Article 4, Para 2. At the same time, and we should never forget, the text goes on with Para 3 of Article 4, which refers to the let's say, loyal compliance with the EU principles and rules. And that's why I believe it's true when many people underline that the two things have to be interpreted together. On the one hand, there is national identity to be respected. On the other hand, there is an obligation upon member states to be loyal to the Union's basic values, principles, rules. And we can only interpret Article 4 correctly if we find, as I said, and as I say again, the balance between the two approaches. But what is national identity? Of course, that's another question. I fully agree with those who underline that, after all, the constitutional identity can be and must be derived from the concept of national identity. So the national identity can be understood as permitting domestic constitutional courts to invoke constitutional identity. The result is complex. The result is that instead of advocating two opposing approaches on the one hand and on the other hand, there is now a new situation. There is a fundamental need for cooperation, a need for interaction, and a need for mutual respect. Without this, it wouldn't or it will not work. So that's why the Germans, again the Germans, of course, they invented this concept, Verfassungsverbund. There is a Bund, there is a binding link between the participants who have to take account of what the other is saying, who have to watch each other and follow each other, and who have to respect each other, and first and foremost, who have to cooperate with each other. And for that, they definitely need a substantial amount of reasonability and self-restraint. Now, of course, I have no time, and it would be a long exercise to go through the case law, either of the domestic constitutional courts or indeed of the European Court of Justice. You know it in any case much better than I do, so I would refrain from going into all these details. One case, perhaps it can be mentioned, it's very recent. It has also a Hungarian dimension. This is the famous Sein-Wittgenstein case, where the Court of Justice, European Court of Justice, did to some extent at least, recognize that the constitutional principle as enshrined in the Constitution of Austria from 1920 had to be recognized or indeed to take into account. So gone is the strict and simple hierarchy. The situation is more diffuse. It's not limited, by the way, to the relationship between European law and domestic constitutional laws. If you take the rules and principles on the global level, it's not as simple and not as strict as it used to be a couple of decades before. It doesn't make the work and the job of the practicing lawyers or indeed university professors easier, not at all. But practicing lawyers say that it might be even beneficial because we have more and more very complex legal disputes because of the multi-level and multi-layer system of law, which is a pluralistic concept and which, of course, makes things much more complex and difficult. But coming back to the European situation. Yes, it is true that we now have a new pluralistic system. Some people call it the composite constitutionalism or composite system of constitutional adjudication. That's all true. But the real question is then, what does it mean in practice? Of course, the content of national identity and the content of constitutional identity in itself can be discussed at length. I'm sure that you will do it anyway during the course of the day. But what we have to see is that if we, for instance, approach the core of constitutional identity, what we have to realize that there is an immense diversity among member states. Certainly much more diversity than, for instance, in the states of United States of America. You can't even compare it in a way. Just to list some of those, these are all, of course, well known. Some of the member states are monarchies. Some of the member states are republics. Monarchs are, of course, not elected. But even presidents in some of the member states are elected directly by the people. In some member states, they are elected indirectly by the parliament. Some countries even change it, like, for instance, the Czech Republic. The latest election of the president took place by a direct election. Also, we have, member states have pure parliamentarian systems, and at least one of them does have a semi-presidential system. But even the competencies and the prerogatives and the responsibilities of presidents, directly or indirectly elected, are fairly diverse. Now, you have strong parliaments in some countries, you have weaker parliaments in some member states. You have democracies, as political scientists say, based upon competition. Some function more on the basis of consensus. And some are unitary, as we know very well. Some are, of course, federal systems. More importantly, member states may have strong or indeed weak systems of constitutional adjudications. That means that the powers and prerogatives of constitutional courts are also very much different. In some countries, there is not even a constitutional court. In some member states, there is a very strong constitutional court, like in Germany, for instance. And even the scope of fundamental rights can be quite different, maybe not in practice, but at least on the constitutional level. That also comes from the fact that constitutions were adopted at different times. Of course, the more recent constitutions, like for instance the Hungarian one, the Hungarian fundamental law has a very extensive list of fundamental rights because basically the Charter of Fundamental Rights was followed, copied basically for 95%. While, of course, constitutions which were adopted long time ago, they have more restricted lists. But in practice, it doesn't matter that much because, after all, the fundamental rights are also enshrined in Article 2 of the treaty. Now, if I mention Article 2, of course, it's quite clear that Article 2 is prevalent. So Article 2 must be complied with because that's the core of the Union's legal system. It seems to be that there has been no conflict between Article 2's basic values principles and the domestic constitutional laws. But the theoretical possibility, perhaps even the practical possibility, cannot be excluded for the future. Now, as I said, and I would conclude this part, there is no final arbiter. Up till now, there has been no outright conflict. None of the constitutions of the member states has been challenged or objected to by the European Court of Justice. While, of course, the European Court of Justice always underlined that union law has primacy in any case and under any circumstances. But none of the constitutional courts, none of the domestic constitutional courts rejected or challenged a concrete decision of the European Court of Justice. So this kind of mutual self-restraint is functioning already now. So this kind of mutual respect for each other is no doubt there. But this can be maintained only if, as I said, the balance is fully respected between, as it is said, the primacy of union law and the constitutional identity of member states. Now, the balance is indeed a general need, a general requirement. That's why I said at the beginning that this topic, this issue, what you are dealing with today, is very closely related to the general tendencies of the integration, if you want to put it that way, to the future of Europe. Because this old dispute about federal Europe and the Europe of nation states, I believe, and I said so already 10 years ago, is no longer really valid. Of course, we always stick to theoretical notions and theoretical concepts. This is human mind. In fact, even more so, this is perhaps European mind. It's European culture that we always search for concepts, for notions, for theories. And because that simplifies our thinking. But it does not replace it. Plus, it does not always meet the realities. And we have realities in Europe, and we have to respect all those realities. And that's why I believe that what is really important here is the balance again and again. The balance between the integration, basic principles, objectives, policies, and the member states' identities, including the constitutional identity. So, but there should also be a balance among or between institutions. The treaty established that balance. It might be criticized. Some people might point out that it could have been done better, it could have been done differently, but that's how it was done. And in European culture, it's always the law that prevails. So I believe that the balance which was established by the Treaty of Lisbon has to be fully respected. A couple of examples. Of course, the guardian of the treaty is the Commission. Why? Because the treaty did not want to mix up political considerations with basic legal principles and rules. And they thought that this was up to the Commission to decide whether this is something legal or not legal. Because never forget, the whole construction is based upon law. If it had not been based upon law, if European construction would not be a structure of rights and obligations, we would not be here now. This country experienced an integration which was not based upon law, which was called the CMEA or Comecon. CMEA was based upon political and economic domination, of course, of the strongest party. But even when the strongest party exercised some degree of self-restraint, although not very frequently, considerations were always political, never really legal, because it was based upon political considerations, political objectives, and political means. Now, this is the opposite in the European Union. Here, everything must be based upon rule of law, not only in the member states, but also on a European level. Otherwise, we are lost. We will not be lost. Don't worry. I just wanted to underline that this is indeed the cornerstone of the whole architecture. So, of course, you have an ideal place for political debates, and this is European Parliament. That's very, very good. That's very correct. That's the place where political ideologies and values get in conflict. Sometimes you might disagree with the style, with the language, with the rhetorics, but this is, I think, a universal phenomenon. I don't like the present rhetorics of political life at all, but that's, of course, a different question. That is now the way people speak. But all in all, I believe that this is the right place for political debates. And then, of course, you have the Council, because somebody has to represent the member states. And the Council has an extremely important job to co-decide together with the European Parliament. And I think that the Council has to be careful not to get involved in ideological or party political debates, because the Council is there to decide together with the Parliament, but representing, on the one hand, the member states' considerations and interests and views, on the other hand, trying to represent, trying to understand the overall European interests and considerations. And there should be a combination of those. Now, if you include in that the party political considerations, then, of course, the Council might lose its original function, which is extremely important. We all know that. So that is the balance between the institution, which has to be maintained also in the future. It doesn't exclude that the treaties might be amended in the future. Maybe not tomorrow or the day after tomorrow. It doesn't exclude that maybe member states decide to reshape a little bit this balance. they might decide to confer more competencies upon the Union. At least one member state now proposes that a little bit less competence be conferred upon the Union. But these are things of the future. What I believe, and I repeat it again for the time being, we have the basic obligation and the basic interest to respect the law as it is enshrined in the treaties. So, as I said, the rule of law has to be respected and preserved also on a European level. It's not always easy, because we know very well that, of course, political considerations very often take the form of legal arguments. Again, I would say nothing new about that. But we have to be careful. And if we mix up law with politics, then, of course, a difficult situation might emerge. Whatever new system or whatever new mechanism we try to introduce or try to invent, there are two things, maybe more, but at least two things. One is that we have to respect the existing treaties, unless we decide to change those treaties. But if we do not amend the treaties, then we have to respect the existing ones. And that also means that whatever new political mechanism is created, there must be some fundamental guarantees of rule of law, such as, first and foremost, equal treatment, Article 4.2, such as basic legal guarantees for the procedure and for the substance. That means legal remedies. That means, of course, audiatur et altera pars. That means an objective and fair scrutiny of facts and all the circumstances. Lawyers know very well that much depends upon the facts. If somebody says that I'm not interested in the facts, it doesn't work. A judge can never say so. That I'm fed up with the facts. Please don't bore me with all the facts you try to refer to. I mean, this doesn't work. We all know that. So please consider the facts, objectively, reasonably, fairly. And of course, equal treatment means many things. I would conclude with this very, very short anecdote, which is not an anecdote, which is reality, which happened a couple of days ago. A very good intellectual argument taking place between two or perhaps more highly educated, important persons, having a discussion about the Fourth Amendment of the Hungarian Basic Law. And of course, arguments were exchanged, and then one argument was that, look, this thing you have even in a more serious form in this and another member state. So why do you object so heavily against a very similar Hungarian provision? Then again, this provision is basically in full compliance with the situation in such and such member states. I don't want to identify the member states now because they will be, or they are identified anyway. And of course that was the argument which you all know very well. But then came the answer, and that is something which makes me to think about the situation. Not necessarily as a politician, but also as a European human being and as a lawyer. Okay. And the argument was that, yes, you're right, I don't dispute that. This exists, yes, it does exist in this country, it also exists in another country, okay, fine. But these countries are different. These countries are well-established democracies. Yours is a fragile democracy. You are not permitted to do that. Established democracies are permitted to do that. You are not. So, two categories of democracies among the 27 or 29. One is well-established, the other one is fragile. Who decides? Because then please give me the list. List A would contain democracy, let's say number 1. List B would contain democracy number 2. Is this what we visualize for a European future? Is this equal treatment? Is this rule of law on a European level? I doubt. But I leave you with your doubts, and of course you will discuss all the details. My last word is very simple, it's just a word of apology. I have to leave immediately. I'm afraid I was already a little bit too long. Sorry for that, but I wish you a very, very, very successful and stimulating conference. Thank you to all the participants, especially those who have come from abroad, to take the trouble and to enlighten us and to speak to us and to discuss all these issues with us. Thank you very much.